Hi, this video about nuisance, right? Nuisance kacau ganggu, right? Noise, bising, pencemaran udara, yeah. It can be other types of kacau ganggu against us as individual or the community. It can be public or private nuisance, yeah. It is concerned with the unlawful interference with a person's use or enjoyment of land or of some right over it or in connection with it. So talking about nuisance, we're talking about our right to enjoy our land, our right to stay peacefully in your own land, and there is an interference to that enjoyment. Alright, so that is nuisance. The basis for a claim in nuisance is founded upon a balancing exercise centered on a question of reasonableness. In Sanders Clark against Grosvenor Mansion Company Limited and the Alessandri 1900, the court must consider whether the defendant is using his property reasonably or not. If he is using it reasonably, there is nothing which at law can be considered a nuisance. But if he is not using it reasonably, then the plaintiff is entitled to relief. There are two types of nuisance, which is private nuisance or public nuisance. For private nuisance, it affects private rights, such as the ownership of the house. Right, this is my house under my father's name, for example. Private nuisance is something which substantially interferes with the plaintiff's use or enjoyment of his or her land. This is my father's house, and my father has the right to stay here, to do whatever he likes, all right, to do whatever he enjoys to do. So that's it. The plaintiff must prove either actual damage to property or substantial interference with the enjoyment of land. In deciding, for example, if somebody comes to the house and tries to, to blame him for something, so he has the right to chase him away, because that particular person have already obstructed his rights and interfered in his peacefulness, to live in his own house, yeah. Okay. In deciding whether the interference with the land is substantial, the court will consider, the interference must not be reasonable, the interference must be substantial in order for someone or the plaintiff, someone who wants to claim, to take action for nuisance or private nuisance. First, so the character of locality. It is more likely, for example, that the judge will find that undesirable smell is a nuisance in a residential area, that in a long-established industrial area where such smells are common. This is the case of Helen's Smelting Company against Tipping in 1865. Alright, another factor would be, so that is the first factor. Alright, okay, in this case, the nuisance was caused by smell, because that particular person lives alongside with an established industrial area, even though the residential area comes later, means that the factory was there long before the establishments of the residential area, but when the smell was not so common, so bad lah, so basically the defendants, the factory owner, is liable under this situation. So that is the factor of locality, a factor that may be used for the plaintiff to take legal action for nuisance. The second factor would be the time when the nuisance occurs. For example, noise due to drilling which made it impossible for neighboring owners to carry on business between 9 a.m. to 5 p.m. would be a nuisance, as in the case of Daily Telegraph against Stuart. Third factor would be the duration of the activity. Activities that can go on for a long time or that recurs are more likely to be considered substantial. Tiap-tiap hari jamming pukul 12 malam, for example, that is considered as substantial. That cause you a sleepless night for like 2 months, 3 months, so that is substantial. And the fourth factor would be the motive of the person creating the nuisance. Apa motif dia? If a person has a right to interfere with a neighbor's enjoyment of land by carrying out a common and ordinary activity, this privilege is lost if the defendant acts with an improper motive, such as the intention to damage his or her neighbor. Yeah. Okay. This is illustrated in the case of Chan Jet against Elite Granite Marble Industries. The plaintiff had leased the land for horticulture and fishery. They used as a source of drainage an existing system flowing through the defendant's lot. The defendant then built a factory on his land, which affected the plaintiff's flow of water as well as polluting it. The court held that the defendant's earthwork in connection with the construction of the factory constituted as an interference with the plaintiff's lawful use of his land and was therefore an actionable nuisance. Actionable nuisance means the plaintiff can take legal actions for nuisance. Yeah, because we want to take legal action, we must have that, it must be actionable lah. We cannot simply kawan kacau kita sekali kita nak take legal action, cannot. Yeah, so it must be actionable nuisance. So in this case, it is an actionable nuisance. Yeah. In the case of Pacific Engineering Limited against Haji Ahmad Rice Mill Limited, the plaintiff brought an action for an injunction. Injunction is an order for the court to stop somebody from doing something that, as in this case, as in this context, nuisance lah. When nuisance happens and the plaintiff thinks that that nuisance is too much already, so they can firstly ask the court for an injunction order, an order for the court to stop, to prohibit them from continuing from doing the activity. Alright. So the action is for restraining the defendant from burning rice husk on their land. Ini yang sebelah kilang padi lah ni. Alright, bringing and permitting to remain on the defendant's premises rice husk to such quantity and as to cause a danger from fire to the plaintiff premises, and dumping and permitting to be dumped on the defendant's premise rice husk in such manner that the rice husk were carried by wind or otherwise to the plaintiff's property or the employees, servants or invitees. So kilang padi ni sebenarnya ialah, saya pernah nampak kilang padi dekat satu tempatnya, bila dah bertimbun dia punya husk tu, kalau angin datang dia terbang pergi ke rumah jiran dan sebagainya. So that if happens for quite a period of time, so it is considered as nuisance because it is substantial. Remember that for nuisance it must be substantial. Alright, bukan sikit-sikit lah, it must be substantial, mungkin daripada segi amount dan juga mungkin daripada segi tempohnya yang dah orang tak boleh tahan dah sekian lama. Alright, so it was held that the plaintiff had shown ample evidence of injury to property and interference to personal comfort that was caused by smoke, ash, rice husk, and dust, and that this constituted actionable nuisance in law. Alright, the court further stated that it was not necessary to constitute a private nuisance to show that the nuisance complained of should be noxious in the sense of being injurious to health. Tak semestinya udara tu, dia mengeluarkan gas yang berbahaya sehingga menyebabkan nyawa terjejas. Tak semestinya. Alright, tak semestinya. Alright, it was sufficient that there is a material interference with the ordinary comfort and convenience of life. So basically, bila kita bayangkan kita duduk sebelah kilang padi, kan husk tu everyday terbang kat rumah kita, merosakkan kita punya tanaman contohnya kan. Kita punya tiba-tiba tak ada asma, tiba-tiba ada asma. So those are considered as part of interference to our enjoyment or convenience of life. Yeah. And that is private nuisance. Public nuisance is another thing. Alright. Public nuisance is, on the other hand, is something which interferes with public rights. Tadi individual rights. This is public rights, and the person bringing the action does not have to own the land affected. It is an action or in an action which interferes with the safety, health, property, or comfort of the public. The person bringing the action need not have an interest in the land that is affected. The person must show either that she or he suffers some special damage beyond that which is suffered by other members of the community, or the person must get permission from the AG. AG is the Attorney General, Peguam Negara, right? Get permission from the AG to bring the action in the public interest. This is called as a related action. Okay, enough for today for nuisance. My next video will be on strict liability. Okay, stay tuned.